Overseas assets and liabilities form part of the asset pool and are taken into account in any property settlement between the parties to a separation. Those assets and liabilities are also subject to the same disclosure obligations per the court rules, such as things like providing bank statements, the title of the property, any mortgages or valuations, as would be expected with any assets or liabilities within Australia. The Australian Family Court expressly have jurisdiction to make orders concerning international assets by virtue of Section 31(2) of the Act. Section 31(2) states that the jurisdiction of the courts may be exercised in relation to persons or things outside Australia and its territories. The biggest issue that we have to overcome when dealing with overseas assets and liabilities will be the issue of jurisdiction. What that usually means is, does Australia have jurisdiction to deal with the overseas assets, or perhaps would a foreign jurisdiction be better suited to deal with those properties? These are especially in circumstances where you may be seeking things like sale orders, transfer from one name to another, or the foreign assets are significant compared to the Australian assets. Jurisdiction and the appropriate forum are usually determined by the closest connection test. The closest connection test means the country in which the separated parties have the closest connection to. For example, where they usually live or where most of the assets will be situated. And this will usually be the judicial system best suited to determine their matter. It is also important to note that even though the court in Australia will make property orders for overseas assets, the best practice is always to obtain a property settlement agreement in the country where the assets are situated. Why is that, you may ask? This is due to the fact that an enforceable agreement in any jurisdiction where assets are would ensure compliance and remedies in the event that one of the parties do not comply with the orders that were made by the Australian courts. The other factors that you should also take into account would be things like the costs associated in getting such orders in other jurisdiction and the complexities involved in the other jurisdiction. If you've overcome those issues, then the Australian family law rules on deciding what is just and equitable will be applicable to your matter. You can read more about these issues on our website or contact us for a consult today.